For years, Roshni Helpline had been working with police officers to point out a big lacuna in the law, and also in police practice, more than in the substantive law. And the problem was that when a parent went to report a missing child, police officers जो थे वो FIR दर्ज नहीं करते थे और ये तजवीज़ देते थे कि your child is probably just upset and has run away from home and will be back. And as a result of which, a lot of children would be abducted, kidnapped, and transported, trafficked outside of the city, and it would be too late to actually retrieve them. So the investigation process was not triggered unless and until many days had elapsed. And so this led to a lot of advocacy with Parliament around a law called Zara, which is basically based on the tragic case of Zainab from Qasur, who unfortunately had to suffer a very traumatic event. And the predominant feature of this law is its definition of a missing child. And so missing child ki definition, and as I've sort of elaborated in my paper, has been broadened to include any child whose whereabouts are unknown to the parents. And so it does not matter whether 5 minutes has elapsed. अगर बच्चा या बच्ची हस्ब मामूल अपनी जगह पे, स्कूल पे, घर पे मौजूद नहीं हैं और 5 मिनट हुए हैं, तब भी पुलिस अफसरान का ये फ़र्ज़ बनता है कि वो फौरी तौर पर कानून को हरकत में लाएं और FIR दर्ज करें. And so the Zara law is not just about improving police practice and taking it out of the Roznamcha, where it basically gets ignored and missing children's cases are not investigated, but to actually bring it within the proper FIR system and the criminal justice system. So my paper really, as I'm just giving an intro, I just want to make sure that it's accessible to everybody when you read it. So one of the other things that I pointed out in this paper is about legal problems in our child protection laws. So the Zara law, which traces missing children, also relies on the Pakistan Penal Code. Or Pakistan Penal Code, hamara, for those of you who are law students, is obviously an archaic law which we inherited from our colonials. And even though many amendments, positive amendments have been made in it, it's still very sort of punishment focused. And one of the things that we talk about in our feminism and the law class is, inspiration from black feminists from the US, Angela Davis, who's really is leading the prison abolition project, right? Our focus should not be so much on convictions and jail times and enhanced penalties, but should really be in improving our systems, improving the law, improving how we think about elements in the law, and also improving social justice. Educational programs. But coming back to the law, just like rape law requires a lot more on not just punishment, right, and how somebody is going to get sazae maut ya umar kaid ya castration, it should really be focused on substantive provisions on what is consent, right? And young people, law students especially like you, I think are the best positioned to talk about consent and really improve Section 375 and 376 on rape and include more non-exhaustive list perhaps of what consent is or is not. Which brought me to the paper where I talk about mens rea, which a lot of law students know is the mental fault element in crimes, and actus reus. A lot of the provisions around abduction and child abduction, pornography are silent on the mens rea requirement, which is how we need to build discourse that these are strict liability offenses. It doesn't matter if you've committed an offense with a child, whether it's pornography, whether it's trafficking, whether it's abduction, your state of mind is irrelevant. The child's consent is irrelevant because the child is not capable of giving informed consent to such an activity. Right? And so we need to build discourse and talk about what strict liability offenses are and why we have them in the law. अच्छा, दूसरी चीज़ जो मैंने नोटिस की is पाकिस्तान ने एक बैन अल-अक़वामी कन्वेंशन साइन की है 1990 की चाइल्ड राइट्स कन्वेंशन. And because of our being ratified that convention, we've improved our laws. And we do officially recognize the universal age of childhood to be 18, under 18. But then when we look at the abduction provisions or the trafficking provisions in our law, they have all kinds of disparate ages, right? So there are some provisions, अगर मैं 364B, 361, 366, मैं अब इतने ज़्यादा provisions को mention नहीं करूँगी, it's all in my article, लेकिन किसी के अंदर सिर्फ बच्चियों को protection दी गई है और लड़कों को नहीं. कुछ provisions के अंदर लड़कियों की उम्र of protection to procure a girl for sexual favors 16 दी गई है, लेकिन बच्चों की प्रोटेक्शन लड़कों की जो है वो सिर्फ 14 है. कोई किडनैपिंग के प्रोविजन है जिसके अंदर इट ओनली अप्लाइज टू चिल्ड्रन अंडर द एज ऑफ 10, राइट? सो द क्वेश्चन एज अ लॉयर एंड एज अ रिसर्चर to my mind was that where is this coming from? Why do we have disparate age protections in all these statutes, right? Especially statutes pertaining to abduction and kidnapping. Is this based on data that Roshni Helpline is produced from Karachi? Is this based on data that other organizations working on child rights in Islamabad or wherever, whichever city you're from? And if it's not, then it's obviously something that we've just held on to from our colonial past, right? And there is obviously, you know, the impetus or to protect younger children, because people generally believe that younger children under the age of 10, 14 are more susceptible, more vulnerable to crimes of violence such as trafficking or kidnapping. Maybe girls are more, but that's not what the data says, right? So if we look at the numbers given by Sahil NGO or Roshni Helpline, boys are equally vulnerable. Girls and boys have different kinds of vulnerabilities, right? I mean, younger children can be used for begging. Boys who are aged 12 upwards can be used for child labor. A lot of girls who are between the ages of 10 and 14 can be used for sex work. So the more we make our law alive to actual risks and problems faced by children who are abducted, we're not going to make it that rigorous. And I know I'm running out of time. Do I have more time or?
You can finish.
Okay, I'm just going to make one more comment then. So the last comment I want to make is about child labor laws. So in my paper, I have tied together not just, you know, criminal justice laws, ZARA laws, and protecting children against crime, but also labor laws. Now we have, since 2010, 25A in our constitution that guarantees free compulsory education for all children between the ages of 5 and 16. But we have a contradiction in labor law, because even in forget the Factories Act of 1934, right? Colonial era ka purana, needs a lot of amendments, बहुत ही एक अजीब सी mentality में अभी तक function कर रहा है. But even the 1991 law allows children under the ages, above the ages of 14 to 16 to work 7 hours in a factory. And so what we need to think about is, when your constitution is guaranteeing a fundamental right to education for all children between 5 and 16, how do you expect this employment of child a law to be compatible with that requirement if children are working 7 days, right, and also need time for leisure, study? How are they going to exercise their okay.
Thank you, Bira, for enlightening us with your valuable insight. We are looking forward to reading your article further.
Awesome, thank you.
Our second author, Barrister, is an advocate high court from AGHS Legal Aid, Lahore. She was also part of consultations on special laws for women, including workplace harassment law and domestic violence law. Her paper discusses the lack of representative voice in enactment of laws impacting women. May I please have her on stage?
Good afternoon. The paper I'm presenting here today is...
Sorry to interrupt. Before we proceed, we would like to welcome Barrister Malika Bukhari for honoring us with her valuable presence today. May I please have final year law students from Kinnaid College, Sabia Zara and Shafaq Farooq. May I also have Mahek Zaragbari to please join us on the stage? Okay. Then can we have Barrister Saqib to join us? Barrister Saqib, please join us on the stage. Okay. Can we have Bismillah Kiani if she's here? Can we have Rida Hussain? Okay, can we please have Mrs. Nida Osman Chaudhary? Over to you, Bidash.
Thank you. So the paper I'm presenting here today is titled By the Men, for the Women, Lack of Representative Voices in Laws Impacting Women. So when we discuss laws and representation, we must address all three branches of state governance. The legislative branch, which makes the laws, the executive branch, which executes them, and the judicial branch, which implements them. My paper adopts a data-driven analytical approach and presents the current state of representation.
Recording in progress.
At the top tier of all three branches of governance. It then moves on to present a case study from Iceland, a country which has dominated the top position for the Global Gender Gap Index for more than a decade, and then it moves on to some recommendations for a way forward for Pakistan. I'd like to bring forward some of my statistics from the paper. Pakistan has a population of 49% female population, but the representation present at the top tiers of the governance structure of Pakistan is very dissimilar. For the legislative branch, we have 20% female representation, whereas at the executive branch, we have only 11%, and at the judicial branch, excluding the Supreme Court, where we don't have a female judge till date, from all the high courts, we have a mere 5% representation. Probably because of these reasons, Pakistan ranks 153rd out of 156 countries in the Global Gender Gap Report of 2021, better from only Iraq, Yemen, and Afghanistan. Moving on, the case study that I have provided in my paper from Iceland, a country which has a which is very small compared to Pakistan and a smaller population as well, but it is a very good case study because it has a similar governance structure as Pakistan. It has a similar population division as well. It has a 50% female population, but the representation in the top tier of governance is much better. Iceland has 38% female representation in the legislative branch, 46.5% for the executive branch, and 53% for the judicial branch. In depth in my paper, I explain the journey of Iceland to get to this point and the impact of having this improved representation, gender representation on Iceland holistically. One of the best things about Iceland's progressive approach towards gender parity is that they have a special ministry of gender equality, which has a targeted approach in ensuring a structure which promotes gender a balance in the country and works towards improving gender representation. I'd like to conclude by simply stating that the paper in depth explores the laws and the representation in the current state in Pakistan, the detailed analysis of how we can improve the situation and the detailed recommendations for it. But I personally feel that it is about time that we as a state move on from asking women to do more and start doing more for women. Thank you.
Thank you, Beenish. We look forward to reading your article. May I please request the next author to...
Good evening and assalamu alaikum everyone. My name is Shafaq Farooq and I, with my co-author Zabia Zahra, wrote an article about female prisoners and the limitations to increasing their representation in law. So with regard to this article, we would like to highlight that despite the presence of national and international laws to protect female accused and convicts confined in Pakistani prisons, the female prisoners have been treated poorly in the country. And this is most likely because the implementation of the laws drafted to increase the legal representation of female convicts are not implemented in their true sense, nor reflect the purpose for which they were created. So here I think it's worth mentioning to highlight a few laws. For example, the Constitution of our country provides women with the right to due process of law, to be treated fairly without discrimination with regard to other genders, and to be treated fairly. But very sadly, it is to be said that these laws are not implemented to the fullest. So we will be talking about a few reasons why there is limited representation of female prisoners in Pakistan. But firstly, I would like to mention about a survey which we conducted in which practicing lawyers and female students gave their opinion about what they think are the major obstacles with regard to female prisoners' representation in law. So we were actually quite surprised to see the results. So basically 51.7% of the respondents, while having a legal background, were not actually familiar that the Pakistan Prison Rule and the Prisons Act states provision specially for females for the females with regard to their problems. And then we actually asked them about another question, that what do they think are the basic reasons why females do not opt for litigation? And 56.7% responded that basically male dominance is the reason why females do not opt for litigation, and other reasons were the structural defects and the socioeconomic factors. So considering these, I think it is crucial for the Pakistan prison rules to ensure that female representation in prisons needs to be taken in mind while the laws are being drafted. And this is the only way that the women depriving of their basic rights can be actually, can get actual fair representation in law. And basically, I would like to further highlight about the consequences resulting from the lack of female lawyers. So firstly, it leads to the violation of Equal Protection Clause, which is basically the Article 5 of the Constitution. And then it leads to the obstruction of right to fair trial, which is Article 10A. And it further leads to the curtailment of right to privacy, which is Article 18. And furthermore, my co-author Zabia would like to elaborate.
So while Shafaq did cover most of it quite well, I would like to conclude and move towards how we can improve this system. And for this purpose, it would be from introducing special efforts to fix structural defects, from countering cultural impediments, and from actually preventing socioeconomic factors from preventing women prisoners from accessing their right to representation in law. So in conclusion, the paper primarily aimed to evaluate the prospect of how and why the representation of female prisoners in law is limited. So, and how this limitation can actually be increased and improved. So while we, of course, are already identifying and resolving such disputes, we still have a long way to go. And with our independent and collective contributions, we can only hope to do our part and improve the system as well. Thank you.
Thank you so much, Shafaq and Zara. Can I please request Ms. Nida Osman Chaudhry to present her paper to us?
The paper basically that Sarah and I wrote, Sarah is sitting right beside me, is based on the 2 years of our research into the judicial nominations and appointments process at the higher judiciary with a gender lens, because we had noticed that no woman had been elevated to the Supreme Court, so we were wondering where the issues were. And so it wasn't just a legal inquiry, but also delves into some of the historical and the social factors and other invisible barriers that may have contributed to this anomaly that we have in our legal system and in the justice sector. So we looked at pre-British era system as well, and how the judges were kind of appointed during the Mughal period. And from that point onwards, we traced that history and also took it to the contemporary and trendy practices, the global trends, emerging trends, developing all across the globe in present times, and how the entire process has actually evolved from a focus just on professional credentials to other factors of competence and diversity, particularly commitments to diversity, and how the world over principles of judicial appointments now do stress on the fact that there needs to be representation, fair representation when the nominations process for senior judiciary and the appointments of senior judiciary is being considered. And where there are two people of equal merit, the one bringing diversity to the bench shall be preferred. And that was often confused with fettering with the independence of the judiciary. However, generally how it has been, we found how it's been interpreted is that unfettered power is not the same thing as, something which, affects the independence of the judiciary. So while, of course, independence of judiciary is a standard and that should be achieved, but that should not mean that they should have unfettered power and arbitrary power to initiate these nominations. And there needs to be, within the constitutional framework, there's Article 25 that guarantees affirmative action to make these provisions for women to ensure that there is representation. And so the courts and the JCP also have to function within that constitutional framework. So this was basically what we found, and how we can achieve that is something that Sarah will highlight.
Hello, Assalamu alaikum everyone. My name is Saira Raza, and like Ms. Nida Osman Chaudhry mentioned, I'm the co-author of this paper on judicial nominations and gender diversity. I'm also one of the editors of the Pakistan Journal of Diversity and Inclusion, and I want to thank all of you for your time here. Basically, when we were doing research for this paper, we put forward quite a few recommendations that we believe can be very helpful in increasing gender diversity at the bench. What we believe is the first and foremost recommendation that we would like to put forward is a constitutional amendment and reform that could basically give the public a publicly declared process and selection criteria which is clearly defined in terms of scholarship and competence, and could tell what exactly a potential candidate has to achieve or be eligible for in order to become part of the bench. And secondly, we believe that there should be like a document of sort which could be named as the Pakistan Principles of Judicial Nominations and Appointments that could basically act as a clear action plan or roadmap for increasing transparency, credibility, and consensus over judicial nominations and appointment processes. Thirdly, we believe that a standing committee on gender diversity can be established in accordance with how the Judicial Commission of Pakistan works to, monitor, evaluate, and initiate initiatives that could basically be in line with those of what the practices are in the UK and in the US to increase gender diversity in judicial nominations and appointments. Fourthly, we believe that inviting female lawyers, sending applications and letters to female lawyers to fill in vacancies in the superior judiciary can be a good way to bring more women forward in order to encourage them to apply for judicial vacancies and places. This was also one of the things that was done in Ontario, and we believe that taking inspiration from things that were done in other countries can be very helpful at this stage. Fifthly, consultative sessions with the JCP and judicial academies can also be helpful in increasing gender diversity because the younger pool of candidates can take inspiration from the people who are already working there to know how to make their applications stronger when they're applying for judicial positions. And so we believe that outreach events and career development workshops will be very helpful for the younger lot that is applying. Sixthly, we believe that gap analysis studies and legislative and administrative reforms in terms of very clear sexual harassment policies, provision of daycare centers, maternity leaves, and clear and developed infrastructure for providing daycare centers and providing designated parking spaces and toilets can be one of the ways of encouraging women to become part of the legal profession and be more included in the practice. Lastly, we believe that affirmative action as in reserved seats is extremely important because marginalized communities need to have some sort of quota on the bench. They need to be given a 33% quota, like we have mentioned in our paper, in order to have greater gender diversity on the bench and have more women and more marginalized communities take up the position of judges and judicial officers. So this is pretty much what we have recommended in our paper. But why we are doing this and why we believe it's so important to talk about increased gender diversity in judicial nominations is because, just in conclusion, is because we want to call for an objective and transparent criteria for nominations. We want to promote diversity and equality of opportunity in the judiciary. We want to ensure a more intersectional representation at the bench. And of course, we want to increase diversity and inclusion with respect to women's representation in the legal profession as a desirable objective of the rule of law. So thank you so much for your time, and thank you for being here.
Thank you, Sarah. The next submission is authored by Mahek Zaragbari, who explores the access of women to justice in Pakistan from a socio-political lens. She's the founder of the Justice Initiative and co-founder of the ADR Initiative. She's working with Asia Foundation on their project to mainstream ADR. She was shortlisted for the National Mediation Awards UK 2020. May I please request my name to connect us to her? Our next contribution is authored by Barrister Saqib, who has discussed whether law fulfills its purpose of providing care to victims of abuse and violence. Saqib is currently appointed as Assistant Director Legal at the Ministry of Human Rights. Do we have him with us? He's not here. Our next contribution is by a law student who has dilated on international forced labor from a gender perspective. Bismillah Kiani is currently pursuing her LLB graduate from the University of London. Okay, could you please unmute yourself? Can you hear us?
Hello, yeah.
Please present us with
Can
your
you
paper.
hear me?
Yes,
Okay.
yes, we can.
Assalamu alaikum, everyone. Thank you for having me today. I'm speaking from Canada, so it's nice to be able to join everyone. My paper is called International Forced Labor from a Gendered Perspective. So historically, when considering events such as Western colonialism, the transatlantic slave trade, discrimination based on identity and gender is not a new phenomenon. And when we look at the statistics of forced labor, women and girls are disproportionately victimized. So females make up to 71% of modern slaves, 99% of forced sexual exploitation, and 84% of victims of forced marriage. So clearly, this is a systemic and structural problem inherent in our society, our legislation, and economic systems, and it targets females and makes them adversely incorporated into the market activities based on these vulnerabilities. So they often have to prioritize short-term gains, making them vulnerable to exploitive practices, and therefore this perpetuates a poverty trap. The paper that I present today considers the definitions of forced labor, specifically those presented by the International. Couple of limitations that I discuss. The first is that the definition proposed by the ILO fails to recognize the different nuances and degrees of forced labor. So in an empirical investigation of the cocoa and tea supply chains, individuals often were shown to move between both forced and severely exploitative labor throughout their lives, so it makes it very difficult to track. And moreover, there's a misconception that forced labor occurs after a significant event, such as a manipulation, deceit, or kidnapping, when in reality, it is simple as a contract or an exchange of money. And the second limitation with the ILO definition of forced labor is that it does not recognize economic coercion. In other words, if the person has agency to leave their job, this is not forced labor. But when that person's options are either poor working conditions and low wages versus starvation and destitution, the option is often illusory. So the ILO only recognizes physical or psychological coercion conducted by a specific agency or a specific individual. Another key definition that I explain is the often a more popular term that's been used in legislation, such as in the UK, which is called modern slavery. This is often an umbrella term to encompass a variety of different aspects of forced labor, sexual exploitation, and human trafficking. However, I often choose to avoid using this term within this paper, primarily because of A, its ambiguity, B, its potential to shame countries by providing some sort of imperialistic perspective, especially countries that have higher forced labor rates, and then C, because of the emotion that is often attached with the word slavery. And taking all of this into account, the question that my paper tries to answer is that why does forced labor amongst women and girls continue to persist despite the fact that there are numerous national labor laws, international commitments such as the ILO Forced Labor Convention, number 29, and national legislation, as well as corporate social responsibility programs that occur privately. So in order to answer this question and to discover why forced labor still persists, I provide two different perspectives. The first is considering from a supply and demand side theory. So basically, this reveals motivations that from both economic, political, and legal lenses, there are motivations towards keeping forced labor persistent in society. From a supply side, this would mean what factors supply a workforce that's more vulnerable to exploitation, so leading to adverse incorporation, limited labor protection offered by state legislation. There's often restrictive mobility regimes such as tied visas, which prevents migrants who enter countries to find employment and prevents them from leaving those situations. And then from a demand side, which is basically answering the question, why is there a demand for multinational corporations to use these type of labor techniques? And this is often due to gaps in governance. Governments often allow companies to regulate these situations at their own terms. There is irresponsible sourcing practices, concentrated corporate power. And when you look at the numbers, you will see that forced labor is actually a $150.2 billion profit-making business. And the greatest profits are found in Asia-Pacific region because of that large number of victims in Asia. And this type of analysis really validates that forced labor is not a consequence of unethical or greedy individuals, but it's a structural phenomenon. The second aspect that I tackle within this paper is looking at the case study from Pakistan. So I take a look at two specific cases. The first case is Darshan Massey versus State. And this is one of the first landmark cases that addressed bonded labor. And it really solidifies the role of judicial activism in the realm of public interest litigation. In this case, the Supreme Court invoked suo motu powers based on a telegram sent by a group of brick kiln bonded laborers fearing for their security. And they were able to dispense of traditional locus standing and allow the Supreme Court to take a more liberal interpretation and directed the government to declare bonded labor as unconstitutional and urging them to outline legislation, which leads to the 1992 Bonded Labor System Abolition Act, which directly addresses the issue at hand. And then finally, the other case in my paper takes a look at is the judgment of High Court of Sindh from the Circuit Court, Hyderabad, 2002. And this case is significant in demonstrating that despite the fact that there is legislation to tackle this issue, it hasn't been adequately applied in the current context. For instance, in this case, it was significant in not using the Bonded Labor System Abolition Act to help the bonded laborers who had made the plea. And instead, it demonstrated that in order for a person to be a bonded laborer, there must be some sort of physical detention. So
Thank you,
overall,
Bismillah.
the paper I present,
Thank you, Bismillah, for giving us a
yes.
valuable insight. We are running late on time.
Okay, thank you.
Thank you.
Thank you very much for having me.
We now connect to Ms. Mahek Zaragbari, who explores the access of women to justice in Pakistan from a socio-political lens. She's the founder of the Justice Initiative and co-founder of the ADR Initiative. May I please request the team to connect us with her?
Hello, Assalamu alaikum. I hope you can all hear me now.
There's a slight disruption in your
Today I'll be
voice.
talking about my paper. My paper basically seeks to explore the social,
Mahek, there is
cultural, and
disruption
legal
in your
aspects
voice.
of why women face a greater deal difficulty accessing justice in Pakistan compared to men. My second point would be the differences in the criminal justice system for the gender-based violence victims. The paper then also gives an analysis of the impact of the pilot gender-based violence code. And lastly, recommendations in the paper are provided to improve the access to justice for women in Pakistan. I'll be going through some points.
We are sorry for the distortion.
That what the paper is about.
Mahek, there's a lot of distortion in your voice. Sorry, there was disturbance. You can continue now.
All right. So basically, I'll be going quickly over some of the points. Basically, laws exist in Pakistan and laws exist here to protect women. However, enforcement suite of laws is deeply rooted social, cultural, economic barriers and biases. There is a
Sorry, Mahek, we cannot hear you. There's a lot of disruption. Can you use the mic if possible? Or maybe we can reconnect.
All right, we can try to reconnect. I'll see
All
what's the
right,
issue
all
at
right.
my end. Thank you.
Sorry for this interruption. We will now connect to Ms. Rida Hussain. She's a published author and is working with Khayal Creative Network and a practicing lawyer working as an associate at FGE. Can we connect with her now? Rida, please present us with your paper.
Assalamu alaikum, everyone. Before I begin, I would like to thank everyone who is involved in putting together the Women in Law Symposium and awards. It takes immense effort, and I would just like to acknowledge the hard work of everyone involved. I would especially like to thank the entire Women in Law team and Ms. Nida Usman Chaudhry for all their help and guidance with regards to my own paper. The title of my paper is A Court of One's Own, The Importance of Female Voices on the Supreme Court of Pakistan. पाकिस्तान में तकरीबन 50% आबादी औरतें हैं, मगर पाकिस्तान की तारीख में कभी एक फीमेल सुप्रीम कोर्ट जस्टिस नहीं रही। इंडियन सुप्रीम कोर्ट में इस वक्त 4 फीमेल सुप्रीम कोर्ट जस्टिसेस हैं। पहली फीमेल सुप्रीम कोर्ट जज इंडिया में 1989 में अपॉइंट हुई थी। सवाल ये उठता है कि पिछले 74 साल में एक भी फीमेल जज पाकिस्तान सुप्रीम कोर्ट में अपॉइंट क्यों नहीं हुई? बाज़ औक़ात ये कहा जाता है कि जज का काम है कानून अप्लाई करना, चाहे वो मेल जज हो या फीमेल जज, इससे क्या फर्क पड़ता है, बस एक अच्छा और काबिल जज होना चाहिए। ये एक गलत सोच है। इस पेपर में मैंने ये नुक्ता उठाया है कि ख़वातीन का सुप्रीम कोर्ट में आना बहुत ज़रूरी है। उनकी आए बगैर हमारी जूरिस्प्रूडेंस, हमारी सोच तरक्की नहीं कर पाएगी। ख़वातीन का जो नुक्ता नज़र है, ज़िंदगी को जहाँ से वो देखती हैं, वो मर्दों से मुख्तलिफ है। और इस नुक्ता नज़र से हमारी जुडिशरी ना ही ज़्यादा हसास होगी, मगर औरतों के मसाइल को ज़्यादा बेहतर समझ सकेगी। अभी रिसेंटली बहुत डिबेट हुई है कि सुप्रीम कोर्ट एलिवेशन सीनियरिटी प्रिंसिपल के बेसिस पे होनी चाहिए या मेरिट। इस डिबेट में औरतों को एक्सक्लूड किया गया। जुडिशियल कन्वेंशन हुई जिन पे ख़वातीन को शामिल नहीं किया। हिस्टोरिकली भी हमने देखा है कि जुडिशियल अपॉइंटमेंट्स के वक्त फीमेल जजेस को नज़रअंदाज किया गया है। जुडिशियल कमीशन ऑफ पाकिस्तान को ही देख लें, जो कमीशन जजेस अपॉइंट करने के लिए बैठी है उसमें सिर्फ मर्द हैं। हमारे बार काउंसिल भी औरतों को एक्सक्लूड करते हैं और उन्हें टॉप पोस्ट पे नहीं आने देते। ख़वातीन को पूरे कानूनी निज़ाम से एक्सक्लूड किया जाता है। हर जगह औरतों के लिए रुकावटें पैदा की जाती हैं और उन्हें आगे बढ़ने का मौका नहीं दिया जाता। दूसरा जो मैंने पॉइंट लिया है पेपर में वो ये है कि अगर हमारे टॉप कोर्ट में ख़वातीन की आवाज़ शामिल की जाएगी तो ये पूरे कानूनी निज़ाम में जो एक साइकिल ऑफ एक्सक्लूजन औरतों की है ये कम होना शुरू होगी। इस पेपर में मैंने इस बात पे जोर डाला है कि सुप्रीम कोर्ट एक ऐसा इदारा है जो आपके बुनियादी हकूक पे एडजुडिकेट करता है और पूरे मुल्क के लिए कानून इंटरप्रेट करता है और प्रेसिडेंट इस्टेब्लिश करता है। ख़वातीन को सुप्रीम कोर्ट में मौजूद करने से इदारे की क्रेडिबिलिटी में इजाफा आएगा। हमारे जहन में बहुत से रवैये हैं कि अच्छी औरत कैसे होती है, किस औरत को इंसाफ मिलना चाहिए और किसको नहीं मिलना चाहिए। ये रवैये और पुरानी आउटडेटेड सोच हमारी अदालतें, हमारे सुप्रीम कोर्ट के जजमेंट्स में भी नजर आती हैं। इस पेपर में मैंने फोकस किया है सुप्रीम कोर्ट की जजमेंट्स जो 2 फिंगर टेस्ट, जिनसी तशद्दुद और ऑनर किलिंग्स पे आए हैं। इस साल तक 21वीं सदी के दौर तक वर्जिनिटी एग्जामिनेशंस पाकिस्तान में कंडक्ट किए जा रहे थे। अदालत में जजेस सवाल पूछते थे कि औरत के किरदार के बारे में क्या गवाही है, क्या शहादत है आपके पास। बिना सोचे और सवाल उठाए ये प्रैक्टिस चलती गई। अगर एक औरत वर्जिन नहीं है तो ये मुमकिन ही नहीं है कि उसके साथ जिनसी तशद्दुद हुआ है। अदालत में विक्टिम का ट्रायल होता है। सेक्स की आदी, बद किरदार औरत, नॉन वर्जिन जैसे अल्फाज सुप्रीम कोर्ट जजमेंट्स में हमें नजर आते हैं। پوری ٹرائل پروسیس میں ذلت اکیوز کی نہیں، وکٹم اور اس کے خاندان کی ہوتی ہے. جنوری میں لاہور ہائی کورٹ کی خاتون جج جسٹس عائشہ ملک نے 2 فنگر ٹیسٹ کو غیر سائنسی اور غیر آئینی قرار دیا. جسٹس عائشہ کا جو فیصلہ ہے یہ خواتین کے پرسپیکٹو سامنے رکھ کے لکھا گیا ہے. ایک پریکٹس جو سالوں سے چلتی آ رہی ہے اسے چیلنج کیا گیا. جسٹس عائشہ نے کہا کہ اگر 2 فنگر ٹیسٹ کا مقصد یہ ثابت کرنا ہے کہ خاتون سیکچولی ایکٹیو ہے کہ نہیں، یہ استعمال نہیں ہو سکتا. اس فیصلے سے واضح ہوتا ہے کہ خواتین کا نقطۂ نظر کتنا ضروری ہے. جسٹس عائشہ نے ججمنٹ میں لکھا کہ ایک عورت کی کردار کشی کرنا بہت آسان ہے، مگر ایک دفعہ ایسی بات عورت کے بارے میں کر دی جائے اسے مٹانا بہت مشکل ہے. جس طرح یہ ججمنٹ لکھی گئی ہے اس سے اسٹیبلش ہوتا ہے کہ عورت کے ایکسپیرینس اور مسائل کی سمجھ ہے. اس فیصلے سے پروو ہوتا ہے کہ سپریم کورٹ میں خواتین کی آواز کتنا ضروری ہے. دوسرا، میں نے سپریم کورٹ کی آنر کلنگز یا غیرت کے نام پہ قتل جو ہوتے ہیں ان کی ججمنٹس ایگزامن کی. آنر کرائمز کی وجہ یہ دی جاتی ہے کہ عورت چاہے وہ بیٹی ہو یا وہ بہن ہو، وہ ایک اچھی عورت کا جو تصور ہے اس سے ہٹ رہی ہے. ہماری عدالتوں نے آنر کرائمز کے ایکیوز کو ایک طرح سے حفاظت دی ہے. گریو اینڈ سڈن یہ ڈیفینس دیا جاتا ہے کہ مرد اپنے آپ کو کنٹرول نہیں کر سکا اور فوری جوش آ گیا تھا، اس لیے اس نے قتل کیا. اگر ایک آدمی اپنی بہن بیٹی کو ان حال میں دیکھے گا تو یہی ہوگا. اس ریاکشن کو نارملائز کیا گیا ہے. اس ویو پوائنٹ کو چیلنج کرنے کے لیے خواتین کی آواز موجود نہیں ہے. کیا گریو اور سڈن پرووکیشن کا ڈیفینس یوز ہونا چاہیے غیرت کے نام پہ قتل کیسز میں؟ بالکل نہیں ہونا چاہیے، اور اس کو میں نے پیپر میں اور ایکسپلور کیا ہے. پیپر میں اس چیز پہ بھی بات کی ہے کہ حالانکہ گریو اینڈ سڈن پرووکیشن کا ڈیفینس پاکستان پینل کوڈ میں اب موجود نہیں ہے، عدالت پھر بھی آنر کرائمز کیسز میں یوز کرتی ہے. امریکہ میں جسٹس روتھ بیڈر گنزبرگ کافی فیمس یو ایس سپریم کورٹ جسٹس تھیں. ان کے اختلافی نوٹ کافی مشہور ہیں اور ان اختلافی نوٹ سے کافی ڈائلاگ شروع ہوا ہے. ایک کیس جو جسٹس گنزبرگ سن رہی تھی اس میں ایک 13 سال کی بچی کو اسکول میں اسٹرپ سرچ کیا کیونکہ شک تھا کہ وہ ڈرگس کیری کر رہی ہیں. اس بینچ پہ کچھ میل جسٹسز نے اسٹرپ سرچ کے بارے میں کچھ کامنٹس پاس کیے. ہیئرنگ کے دوران میل جسٹسز نے کچھ ایسے کامنٹس پاس کیے جس سے یہ لگ رہا تھا کہ وہ اسٹرپ سرچ کو بہت لائٹ طریقے سے لے. میل جسٹسز نے اپریشیٹ نہیں کیا کہ ایک اسٹرکٹ سرچ 13 سال کی لڑکی کے لیے کتنی شرمندگی پیدا کر سکتی ہے. I would just like to read what Justice Ginsburg said about the strip search and the comments made by her male colleagues on the bench. She said that they've never been a 13-year-old girl. It's a very sensitive age for a girl. I don't think that my colleagues, some of them, quite understood. The point that I'm trying to make is that lived experience is important. آخری میں نے سپریم کورٹ کی میجورٹی ججمنٹ مختارہ مئی کیس میں اینالائز کی ہے. یہ کیس ایک پرائم ایگزامپل ہے کہ ہماری عدالتوں کو جنسی تشدد کے کیسز کو سمجھنے کی بہت ضرورت ہے اور ایک عورت کے پرسپیکٹو سے سمجھنے کی ضرورت ہے. مختارہ مئی کیس میں عدالت نے 5 اکیوز کو بری کرنے کی وجہ یہ دی تھی کہ FIR 8 دن بعد درج کیوں کیا گیا. عدالت نے کہا کہ مختارہ مئی تو ایک طلاق یافتہ عورت ہے اور اس ڈیلے کا کوئی جواز نہیں پیش ہوا، اور اگر کوئی وکٹم ان میرڈ عورت ہوتی تو ڈیلے کی سمجھ آتی. ایک دفعہ پھر عدالت نے پرانے رویوں کی بنیاد پہ ججمنٹ دی. کیونکہ مختارہ مئی نے FIR 8 دن بعد درج کیا تو وہ جھوٹ بول رہی ہے. اگر مختارہ مئی کی کتاب پڑھیں تو اس میں وہ کہتی ہیں کہ ریپ کے بعد انہیں لگا کہ انہیں خودکشی کر دینی چاہیے. بہت ہمت اور طاقت کی ضرورت ہوتی ہے FIR درج کرنے کے لیے، اور کوئی فرق نہیں پڑتا کہ اگر کوئی عورت طلاق یافتہ ہے یا نہیں. مختارہ مئی کیس میں عدالت نے 5 اکیوز کو بری کرنے کی وجہ یہ بھی دی تھی کہ اکیوز نے پہلے موقع پہ ریپ نہیں کیا. عدالت نے کہا کہ مختارہ مئی اکیوز کے گھر گئی تھی مرد حضرات کے بغیر اور یہ موقع تھا کہ اس کے پاس ریپ کرنے کا، مگر کچھ نہیں ہوا. اس فیصلے سے واضح ہوتا ہے کہ جنسی تشدد کو سمجھنے کی ضرورت ہے. عدالت نے ریپ کو ایک لاسٹ یا ہوس کا ایشو بنا دیا. اس میں ایک پاور ڈائنامک موجود ہے. کشمیر یا بھارت میں ہم دیکھتے ہیں کہ لوور کاسٹ کے لوگ اپر کاسٹ کو کیسے جنسی تشدد کا نشانہ بناتے ہیں. اس لیے ریپ جنگوں میں بھی بہت ہوتا ہے. ایک دفعہ پھر ایک ان چیلنج متھ نظر آتی ہے عدالت کے ججمنٹ میں کہ ریپ ایک ٹائم آف لسٹ ہے. پاور کا ایسپیکٹ جو ہے وہ بالکل اگنور کیا گیا. ہماری عدالت انہی پرانے رویے، سوچ اور خیالات پہ چل رہی ہے. اس سوچ کو چیلنج اور اس کا مقابلہ کرنا بہت ضروری ہے. اور اس پیپر میں نے یہ پوائنٹ لیا ہے کہ اس کا سب سے افیکٹو طریقہ یہ ہے
Thank you,
کہ
Rida,
جو
for
عدالت
presenting
پورے
us with
ملک
your
کے لیے
paper.
قانون اور پریسیڈنٹ بنا رہی ہے اس میں خواتین کو شامل کیا.
Thank you. Thank you. Thank you everyone for showing great resilience to the new technology. I would like to thank everyone for using their pen to voice thematic issues. I would now like to request Honorable Barrister Malika Bukhari, the champion behind all this work, Parliamentary Secretary, Ministry for Law and Justice, member of the National Assembly, to grace the occasion with her closing remarks. She's a patron of this collaborative action for increasing women's representation in law. Mrs. Bukhari is the pioneer of progressive legislation for women's rights, including the anti-rape laws. Over to you.
Bismillahirrahmanirrahim. Thank you very much for your kind introduction. I'd just like to begin by saying that it's an honor and privilege to be speaking here today. And I think it's a great historic moment for Pakistan as a country, because we are hosting the first Women in Law Awards that our country has seen. We're finally formally celebrating women's achievements in the legal profession, whether they are lawyers, academics, law students. So it's a great moment for me personally as a public office holder. And it's very refreshing as well, I think, because I always find myself alone as a woman in a room full of men. And finally, I'm in a room full of women. So it's a great moment, and it's very refreshing for me as a public office holder. You know, the issue of women's representation clearly is very close to my heart. I'm a woman parliamentarian, and as a political activist, as a gender equality activist, as a lawyer, I have gone through many stages personally to be where I am today. Holding public office comes at a huge personal and professional cost to women. It's a huge challenge, but we must always be present in Parliament. And I would like to echo what the last speaker said. You know, she talked about how women judges, whether it is Baroness Hale from the UK, whether it is Justice Ginsburg in the United States, whether it's Justice Nasra Iqbal, who is present here today, honored to be speaking in your presence, ma'am, and whether it is Justice Aisha Malik. They have a huge contribution to make to the legal profession. They bring that absent gendered lens that is missing when men pronounce judgments. Not that they can't do it well, they can. They do it very well. But I think if we have a woman's perspective, it changes the dynamics of the judgment, as the speaker highlighted, and it is very important that we have women represented at all levels of the legal profession. The numbers have been documented in the baseline study that was conducted, and NIDA has, and Group Development Pakistan has compiled that. And we know that women are not adequately and equally represented in the legal profession. We comprise half of Pakistan, but that doesn't equate or adequately be represented in the numbers as judges, as prosecutors, as advocates, as any other duty bearers, as police officers, and we unfortunately missed a very important opportunity to nominate the first woman Supreme Court judge for Pakistan. And I think that was, from my perspective as a woman lawyer and a parliamentarian, a black day for Pakistan, because the Judicial Commission of Pakistan did not perform the duty that was entrusted to them. This may be my personal opinion, but I think we missed an opportune moment. It is nice to see that we now have a female nominated as judge in the Islamabad High Court, and we have women judges in other courts of Pakistan, in the lower judiciary and in the High Court, but it's a missed opportunity. And I hope that matter is not settled and put away, and that we finally and very soon have our own woman Supreme Court judge, which is essential for our country. Moving forward, I would like to speak a little bit about the great submissions that were done by all the authors that are sitting here today. Many congratulations to all of you. You did a tremendous job. I always reiterate at the Law Ministry, when the Law Minister and I debate on the quality of women lawyers. that these women lawyers are invisible. They're there, they're bright, they're brilliant, they're strong, they are brave, they're committed, and they're a complete great addition to the legal profession. Just that we don't see them, we never talk about them. And I still remember the day when Nida and I and Valerie and Anisa Agha, I think she's also somewhere here today, we spoke, we had a small huddle, and we spoke about the importance of visibility of women lawyers. We had a very interesting debate with the law minister, which I will not tell you all about today. But the gist of it was that we don't have enough good female lawyers in Pakistan. And I say, Nida, we must tell the law minister that we have brilliant female lawyers in Pakistan. We just don't talk about them enough. And therefore, we now have a portal dedicated to highlighting women lawyers. We now have our very own gender and diversity journal, which documents the work of great female practitioners. And I think this is going to go a long way for our country. Even if Pakistan Tehreek-e-Insaf is not in government, we have ensured that the Ministry of Law and Justice and whoever is the law minister continues this very important initiative every single year, because it is much needed in our country and something that must take place on a yearly basis. So very happy to be doing this here today. Congratulations to all of you for the work that you do. And I very much look forward to the Women in Law Awards. It's a much awaited awards ceremony. It's taken a lot of hard work by the people who were involved in it. Nida, of course, Valerie Khan, Anisa Agha, and the Ministry of Law and Justice just supported the initiative. And we're very proud partners of the Women in Law Awards and the Diversity and Inclusion Symposium. I'd just like to leave a thought with all of you that, being represented and at all levels of the legal profession, I can relate to the fact that it's a tough journey. But it's a journey that all of us must make. It's a journey that is very important, from a personal perspective, and I always talk about my personal journey. It's been very difficult, it's been tough. This morning when I was preparing for this symposium, my mother was being treated for cancer in a hospital. I was talking to my son on the phone to ensure that he studies for his exams, and we were trying to also debate the NAB law amendments in the ministry, the Standing Committee for Law and Justice. So it's a lot of invisible work that women do behind the scenes. It doesn't matter whether you're the Prime Minister of Pakistan or you're the Law Minister or you're the Parliamentary Secretary or you're an advocate or a justice. There's a lot of invisible workload that women undertake. And that's a real barrier to them achieving the level that men sometimes do with no hidden barriers at all, no extra commitments, no additional workload. So yes, many obstacles. Many challenges, but women have done it before us. We have Justice Nasra Iqbal here sitting here today. She's done it before us. We have judges in the High Court who are doing it. We've had a female Prime Minister. We've had only one federal law minister. I hope we have more in the future. We've never had an Attorney General for Pakistan that is a woman. And we've portfolios that are given to women in the cabinet are generally portfolios that are seem to be good for women or more women-like. So we never have had a woman finance minister at the federal level, I think, or a woman defense minister, a woman minister for interior. So we have to progress as a nation, but we are. There is good news. Representation is increasing. So congratulations to all of you. I'd like to leave you with that note of hope and look forward to seeing you all at the award ceremony. Thank you very much.
Thank you, Barrister Malika Bukhari, for your unshakable support to promote gender equality and fight gender-based violence. I would request you to please present certificates to our paper presenters. May I please call Justice Nasira Iqbal on the stage? Abira Ashfaq. Venus Zia. Bismillah Kiadi. Shafaq Farooq and Zabia Zahra. Nida Usman and Sara Raza. Rida Hussain. Rida Hussain, Barrister Saqib and Mahek Zaragbari. We will be delivering their certificates to them. Yes. May I please request you all of you to please take a picture? Can I have Mrs. Valerie Khan on the stage? Towards the end of the symposium, I would again like to extend a special thanks to all the dignitaries for taking time to grace us with on the occasion. A round of appreciation for the team of GDP, Women in Law Initiative, and every other individual who has helped us to make this possible and contributed towards the success of this event. May I please request all of you to gather for a group photo? It's outside the hub. We will have a tea break after the group photograph. It's a short break and we will be requesting you to please come back.
Recording stopped.